Good morning, colleagues, and welcome to the 23rd meeting of the Referendum Scotland Bill Committee. As usual, can I ask make sure that everyone has their mobile phones switched off? We've had no apologies for this particular meeting, so we can just proceed to the business. And the first agenda item 1 is about decision on taking a business in private. We have a draft report on the instrument to consider, and obviously we're considering that later in the agenda. Are members content that we take the draft report in private? Okay, that takes us to agenda item 2 and the oral evidence session. There are two main items, both relating to the affirmative instrument laid under the Franchise Act, dealing with issues of anonymous registration. And as is normal with such instruments, the committee first has the opportunity to take evidence from the Minister in charge. On this occasion, it's the Deputy First Minister, and from the officials, and then we shall debate the instrument. So I welcome the panel of witnesses today: Nicola Sturgeon, the Deputy First Minister; Helen Clifford, the Bill Team Leader for the Referendum Bill; Gillian Cross, the Elections Policy Advisor to the Scottish Government. Deputy First Minister, I understand you might want to make some brief opening remarks.
Thanks, Convener. The draft Register of Young Voters Anonymous Entry Scotland order has two aims. Firstly, it extends the list of orders or interdicts which can be used as evidence for anonymous registration in the Register of Young Voters to replicate changes being made by the UK Government in respect of its registers. And secondly, it allows chief social workers to delegate the responsibility for attesting applications for anonymous registration in the Register of Young Voters. The requirements for anonymous registration are contained in the Representation of the People Act 1983 and the 2001 Scottish Regulations as amended by the 2007 Amendment Regulations. In order to be registered anonymously, the safety of the applicant or someone in their household must be at risk. Any application must be accompanied by evidence either in the form of a listed court order or interdict or an attestation by a qualified officer. The Scottish Independence Referendum Franchise Act 2013 applies these provisions to the Register of Young Voters for the referendum with no significant modifications. However, the committee will recall that following concerns raised during consideration of the Franchise Act, a committee to replicating the UK Government's planned changes to the rules surrounding anonymous registration in its register, and this order achieves that. These changes are contained in draft regulations which are currently before the UK Parliament. The UK regulations extend and update the list of orders and interdicts which can be used as evidence of entitlement to register anonymously to better reflect the orders that can be issued by the courts, particularly Scottish courts. In addition, Scotland's Commissioner for Children and Young People also expressed concerns about the practical application of the process of attestation. The Government has been careful in developing the referendum legislation to listen closely to the concern of stakeholders and, where appropriate, to act on those concerns. Following correspondence I've had with the Children's Commissioner, officials spoke to electoral registration officers who confirmed that the process of attestation could sometimes be difficult to use, in particular because of the requirement for a particular level of seniority of the police officer or social worker attesting the application. In order to ensure that any vulnerable young person who is eligible to register anonymously is able to do so, and to streamline the process, this draft order will therefore allow chief social workers to delegate the responsibility for attesting applications for anonymous registration in the Register of Young Voters. EROs agree that this is a sensible and pragmatic way forward. We've also discussed the practicalities of these proposals with the Association of Directors of Social Work. They are also content that the proposals are workable, and officials are working with them to update the guidance available to chief social workers. So in short, Convener, I believe that the proposals contained in this draft order respond to the concerns that have been raised. They're workable and practical, and I'm on that basis happy to answer any questions that members might have.
Thank you, Deputy First Minister. Any members wish to make a question? I understand Stuart Maxwell has a question he would like to ask.
Thank you, Convener. Good morning, Deputy First Minister. Back on the 14th of March, I raised some of these questions with Ken MacDonald from the Information Commissioner's Office and indeed Tam Bailey, the Commissioner for Young People, about vulnerable young people who would be faced with the difficulty of wanting to register, but obviously the danger, I think it's not too strong a word, of not being anonymised. Now, I've read your letter to the Commissioner. Does this change in the process, or do you believe this change in the process will allow effectively young people to easily get through the attestation process remain anonymous, particularly given and bearing in mind the mobility and the difficulty that these young people face. Does this process effectively answer the the Commissioner for Children's and Young People's concerns in this area?
I believe it does. I mean, obviously, I'm not going to speak for the Commissioner for Children and Young People, but I believe the proposals in this draft order do address those concerns. When we had further discussions on the back of the concerns that Tam Bailey had expressed, what we found was that there was a general concern that the current procedures were overly cumbersome given the level of seniority of social worker that had to be involved in the attestation process. So in both extending the range of orders that can be used as evidence, but also, I think more crucially in respect of the register of young voters, allowing the chief social worker to delegate that responsibility to the social worker that perhaps knows best what is going on in the life of a young person, then I do think it substantially addresses those concerns, and it will create the conditions in which young people who are at risk and who would want to exercise their right to vote but do so anonymously have a process that is not overly cumbersome and enables them to do so.
Thank you very much for that. But have you had a response from the...
I have had correspondence with the Commissioner for Children and Young People. I last wrote to the Commissioner on the 9th of October with a detailed explanation of a proposal. I think that letter was copied to the committee. I've not yet received a reply to that letter, which is why I'm reluctant to speak for the Commissioner and give what his view would be. But I believe, based on the correspondence that we've had, that these proposals go as far as it is reasonable to go in addressing the legitimate concerns that were raised.
Okay, thank you very much.
Sure, Lewis MacDonald.
Thanks very much, and thanks for that presentation. I wonder, in terms of the delegation of the power to provide an attestation, that I suppose is based essentially on the issue, on the question of whether it's possible to obtain that attestation readily. I think you said there was a risk of it might be a little cumbersome in terms of the previous level of seniority required. Can you give us an indication on that basis of what sort of numbers you anticipate might be involved here? Because clearly from existing anonymised registration, there will be some global idea of how that impacts on voters over the age of 18. And therefore it would probably be a bit of an extrapolation to suggest what that number might be for under 18 age voters, but nonetheless it might be helpful to have a ballpark figure and also a sense of whether there is a particular issue in particular authorities with obtaining attestation at a senior level.
I mean, given the numbers of anonymous entries that currently exist on the local government register, which I think is fewer than 100 at the moment, then I would not anticipate that we will be dealing with large numbers of anonymous entries in the register of young voters either. However, that said, I mean, I suppose I would draw a parallel to the discussion we've had over the last few months about children of service personnel. It might be a very, very small number of people, but it is nevertheless important, if we are serious, as the government is, about ensuring that everybody who is eligible to vote in the referendum gets the chance to exercise that right to vote. Then even if it's a very small number of people, we need to be confident that the procedures in place are appropriate and proportionate. As I say, the concerns were raised, they were articulated at this committee, they were raised by the Commissioner. We, in the spirit of trying to listen to and address concerns, had wider discussions, and the feedback was that the current procedures would be seen as perhaps overly cumbersome and not proportionate. So I think this addresses that concern. I don't think it would be possible, nor for that reason sensible, for me to put numbers on how many we might be talking about, because I don't think it's possible to do that. But I think I could sit here with reasonable confidence and say we would be looking at small numbers of people. But even if it's only one or two, it's important that they're able to have procedures in place that allow them to exercise their right to vote.
It would be fair to conclude that the point then of delegating authority is for streamlining the operation rather than to deal with any
absolutely.
Numbers issue.
You know, I think to summarise the concern, when it was a senior social worker or police officer, that individual may not be, for understandable reasons, intimately aware of the particular circumstances that is giving rise to the application for anonymous registration. So the ability to delegate that to the social worker who is dealing with the young person both streamlines that and I would suggest probably makes it more likely that the individual circumstances are treated appropriately. So for both of those reasons, I think this is a sensible procedure.
Rob Gibson.
To ask, you know, how you're going to make the people aware of this once these orders are passed.
We are, and we're going to continue to work with the Association of Directors of Social Work to update the guidance that they provide to chief social workers on their role in the attestation process. We're also working with EROs to develop guidance on registering vulnerable young people. This guidance and the guidance in the young voter registration form makes clear that anybody with concerns over their safety should discuss this with the ERO in the first instance. The ERO guidance on registering vulnerable young people also indicates that EROs should proactively engage with key individuals to explain the different registration options that are available to them. So we'll be taking all of those appropriate steps to make sure that there is the right level of awareness of this.
Honourable Goldie.
Convener, I noticed, Deputy First Minister, you said earlier that you obviously anticipate the Chief Social Worker authorising another social worker. The drafting actually says any person. I mean, so presumably that could extend to a carer or someone else who has knowledge of the young person.
Yeah, I mean, that's deliberate drafting. I mean, the intention here is that it is the appropriate person. So it could be you know, the head teacher of a school, for example. It could be another official within the council. You know, the guidance that we're going to prepare for chief social workers is obviously important in making sure that they have proper understanding of the procedures and how best to use them and the appropriate circumstances in which they would be used. But the intention here is the person with the understanding of the child's circumstances that is best placed to do the attesting.
Tavish Scott.
Yes, thank you, Convener. I wonder if I could just pick up a very small point from the note, the policy note that was circulated to the committee by the government on dated 31st of October on the financial effects. And I entirely appreciate that this is very illogical given the Deputy First Minister's answer to Lewis MacDonald's questions. But for my public audit hat on and for my pedantic nature, is it possible, if not today at some point, just to define what significant means in the context of financial effects? I appreciate government always rightly have to give some account for what is a significant financial effect of a proposed piece of legislation or regulation. But in this context, is there a de minimis level that government operates to, or is there just a financial assessment made of a particular measure being proposed?
It is a financial assessment that's made. There's not kind of set amounts set down. I'm happy to write to the committee after today's appearance and set down to the best of our ability the process that we would go through in making that assessment. But as Tavish Scott rightly points out, given my answer to Lewis MacDonald, this is likely to be small numbers. Then there's not likely to be much of a financial impact at all. But I'm happy to provide whatever information we can on the process of assessing what is significant and what isn't.
Stuart McMillan.
Just it follows on from Annabel Goldie's question. In terms of it's not just about social workers, it's going to be, as you said, Deputy First Minister, about the appropriate person. And then also your answer to Tavish Scott there in terms of you don't anticipate don't anticipate large numbers in this. With that being the case, do you think actually that this is going to be workable and fully effective? With it being kind of such a diverse range of individuals who might actually be included?
I do think it will be workable. Obviously, we've taken care to have discussions with the right people to make an assessment as to whether it is workable or not. We've discussed with EROs, we've discussed with ADSW. Both of those organisations are satisfied that this is a workable proposition. I think EROs have described the proposal as sensible and pragmatic. As I've said on a couple of occasions already this morning, we're going to update the guidance that's available to chief social workers. So I am perfectly satisfied that this is a workable and effective change to procedure, and that it will meet the stated objective, which is to make sure that even if it is a small number of people, any young person that is at risk that wants to exercise their eligibility and right to vote should be able to do so. And that's been the principle that's run through all of our discussions on the franchise and the arrangements for the referendum. We want to make sure that everybody who has the right to vote in this referendum has no barriers or no avoidable barriers in their way to doing so.
Okay, thanks. Bill Goldie has got another supplementary.
Deputy First Minister, is there a qualifying age for the any person?
No. There's not, but you know, the any person is. I mean, that may be something we want to cover in the guidance that is being updated. But the intention here is that the appropriate person would be a person that has a relationship in that professional sense with the child.
That's not what the regulation says with respect. I mean, I'm simply thinking if a sibling came along age 14 and said, it's okay, I'll say things have to be anonymous and so you can get your vote.
I think that the key point to understand here, though, is the chief social worker is the person who has to delegate responsibility. So the chief social worker has the responsibility of making the judgment as to whether the person that responsibility is being delegated to is appropriate. So the responsibility, in that sense, still lies with the chief social worker.
Just wanted your
you can't. The appropriate person. So I'm just. The order provides the chief social worker's authorisation to be attached to the application for anonymous registration along with the attestation. That means the EROs are able to be satisfied that the person is authorised to have attested the application without the need for them to make further inquiries. So it's not the case that anybody, in your example, the sibling can come along and say, you know, I judge myself able to attest this application. It has to be the chief social worker that says that that person is appropriate to have that responsibility delegated to them.
Just wanted.
Thank you for pointing out that.
Just wanted your presence here to feel justified.
I'm as ever grateful to you.
And now we've got Lewis MacDonald.
In the same spirit of complete certainty, there's clearly no explicit link to the Children and Young People Bill that's before Parliament this afternoon, but that does make provision in relation to young people for a named person. Is there an implicit link in the provisions of this order?
I'm not the Minister responsible for that particular bill, so I'll stand to be corrected if I give the wrong answer right now. But no, I don't think there is an implicit or an explicit link between this. This is a change in procedure for very specific purposes, in this case voting and voting in the referendum. Obviously, we don't have the power to make this change in terms of other elections, so it's very specific to voting in this referendum.
That's the questions exhausted. Thank you, Deputy First Minister, and your officials. I think we now move on to agenda item 3, which is the final item of today's agenda. Is the debate on the instrument itself, on which the committee has just taken evidence. The Deputy First Minister has lodged a motion inviting the committee to recommend approval of the instrument, and this is set out on the agenda. I invite the Deputy First Minister to speak to and to move the motion.
Convener, I believe that the draft order achieves the practical aims that we've been discussing of ensuring consistency as far as possible between the register of young voters and the local government register for the referendum, and ensuring that any vulnerable young person who should be able to register anonymously can do so. So I move the motion, and I hope the committee will feel able to support it.
Does any other member wish to contribute? No other member wish to contribute. I therefore put the question. The question is that a motion S4M 08328 in the name of Nicola Sturgeon be agreed to. Are we all agreed? Thank you. Thank you, Deputy First Minister and our officials for attendance. The next meeting is scheduled for the 5th of December, when the committee will consider a draft report on the instrument considered today. There are no further meetings of the committee currently scheduled. I formally close this meeting.